So let me introduce our speaker. And today we're happy to welcome Cynthia Hall, and she's going to be speaking on the PRC and climate change, what's taking so long. Cynthia has served as District 1 Commissioner of the New Mexico Public Regulation Commission since January 2017, following her election the November before, and she has been Vice Chair since January 2019, and previously she was an Associate General Counsel to the PRC, Assistant Staff Counsel in the New Mexico Public Service Commission and Energy and Minerals Department, and she's had a number of other roles. And if you're curious, we have a more detailed background in our latest issue of NMSR reports, right there on the front page. So without further ado, let's welcome Cynthia Hall.
Thank you very much. Just one minor correction. I was, I'm not vice chair right now. I was from 2017 till beginning of 2019. So but I'm not now.
Okay.
Yeah. So actually, wait a minute. For 1 year, it was for a year, 2017 through 2018. I don't know what you were seeing, but anyhow, it was for 1 year. But anyhow, it's just ceremonial, really. Except I did have to run some meetings, but that's a chore, so it's nothing fancy. Anyhow, I'm really pleased to talk to you guys today. I'm pleased to finally get face to face with your organization. I always admired it from afar, and I was really glad many years, well, not that many years ago, maybe 15 years ago, when you guys stood up to creationism in school, and I thought that was really good. My kids are in school then, and I thought that was just, you know, really going in the wrong trajectory in terms of education. So I'm glad you guys took care of that problem. And I'm delighted you want to hear about this kind of business at the PRC. A lot of people think it's too dry, but to me, it's very vital because probably because of the perspective I have that I bring to the office, which is that of not just a lawyer who has worked at that agency for a long time and understands the details of the process and so forth, but also as a former scientist and environmental practitioner, I guess, because I was involved in environmental law in most of my career. And I ran in 2012 and lost. It was a three-way race. I came very close to I was a close second, but I didn't win. So I was encouraged to continue on in my law career until 2016 when I won. But when I ran initially, it was for two reasons. One is that I realized that the commission could have a significant influence, at least within the borders of our state, on activities that might help to diminish or forestall some of the worst effects of climate change if they were carried out on a large scale, such as the use of renewable energy, because the commission regulates monopoly utilities in our state, and those are the gas, water, and electric industries. And I was aware of climate change increasing during those years. That was in 2012. Well, I mean, I think we'd all been aware of that, of climate change since probably 20 years prior to that, the late 90s. But in any case, I ran because I was aware that the commission and its regulatory activities could have an influence over the amount of emissions from the electric industry in our state. And at that time, and I think it's probably still true, the electric industry was the greatest emitter of greenhouse gases. Now, and I understand that people consider the transportation now to hold that title of the greatest greenhouse gas emitters, but I'm sure if the utility industry isn't the greatest emitter, it's very close. But in any case, so, and in fact, while I've been on the commission in this term, there's been a real change in the way we handle the emissions of greenhouse gases. When maybe I should go through my background a little bit related to the commission. I worked at an agency called, well, it was a former version of the PRC called the Public Service Commission, and I worked there for a year from between 1985 and 1986, and I was not just out of law school, but pretty close to being out of law school. Actually, prior to law school, I was a scientist for a number of years, so I wasn't quite wet behind the ears in terms of my age. I was in my 30s by then when I got out of law school. But I worked at the commission, and there were 3 appointed commissioners then rather than 5 elected commissioners, and I'll talk about that more later. But in any case, I was working there, and it was a very professional atmosphere, and I really liked it quite a bit. It was a fascinating subject, really top-notch staff, very smart commissioners. And but then I got married and we moved out of state, so I couldn't continue my job there. But eventually we came back to New Mexico, although we were living in Albuquerque, not Santa Fe, so I couldn't really. And I had small kids. I was really quite busy with other stuff. So I didn't get back to work at the commission until 2008. And by then they were, commissioners were elected. And there was a noticeable difference in terms of their competence on the commission, their understanding of the subject matter. And I was in the office of general counsel, which are the lawyers who advise the commission. So it was up to me, along with the other attorneys, to analyze the legal aspects of cases that came before the commission for them to decide, summarize that information, and present it to the commission in their weekly open meetings that they conduct, in which they make decisions on cases in front of a public audience. And at that time, there was a standard rule that we had to provide no more than a 1-page memo to explain each case. So I found that concerning because, you know, some of these cases are enormous. For example, if just to give you the perspective, if you're a large utility and you want to raise your electric rates, you can't just do that because you're a monopoly. And our agency has to approve whether or not you're going to raise your rates. You know, you don't experience competition like all the other businesses who, if they want to raise their prices on goods or services, they can just do that. Our agency stands in the place of competition with respect to the monopolies. So we have to look very closely at why they want to raise their rates. And we want to look at how much they want to raise their rates, what their revenue stream has been, what their costs have been. It's a huge accounting endeavor, really, and legal endeavor. And we hold cases, we hold trials, essentially, in order to go through all the evidence that any company has to present through witnesses, sworn witnesses on the stand before we approve those things. So, and the testimony itself can run thousands of pages, and the recommended decisions that are written by the hearing examiners who actually hear these cases, they sit as trial judges really, but they're administrative law judges basically, can run their recommended decisions to the commission can be upwards of 200 pages on a big case. Anyhow, we'd have to distill that down to 1 page for these commissioners because they really weren't comfortable reading the briefs from other people. And so I realized that I could probably do the job better than they could. And then, you know, so I was thinking after about the first month, and after about the second month, I thought, well, I guess I better try. So that's when I decided to run for the commission. And so, as I say, I ultimately got there in 2016. Let's see. So some of that is information that I want to have you remember when we talk about appointed versus elected commissioners, which I'm going to talk about later in this talk. But for now, for this part of it, I'm still talking about the Energy Transition Act. So the Energy Transition Act, well, let me back up a minute. I did also touch on our process. So basically it's a trial type process. I want to explain that as we move forward to talk about the Energy Transition Act. As I mentioned, we have a trial type process. Our agency is like a mini court system. We have 6 hearing examiners who sit like judges, like district judges, and they hear cases. And then they write us recommended decisions. The cases involve basically a battle of experts. If a utility wants to raise their rates, they will, for example, well, PNM, because they are the largest of the 3 monopoly electric utility companies we have. Say they come in, they'll file their application, which is actually a short legal brief with lots of evidence attached. And those documents can run hundreds and hundreds of pages, but it contains a lot of the graphs and verbal, written testimony of their witnesses attached. They file it. So that testimony is pre-filed and that commences a case. There is a batch of engineers and economists who comprise the staff at the commission. They are the other side of that case. They're supposed to represent the public interest. There are attorneys called staff attorneys, which I was in my first job in the 80s, who represent staff before the hearing examiner. So you've got 2 sides of the case. You've got the utility on one side and you've got staff on the other. And they each have lawyers and they each have expert witnesses. And then you have interveners. In a large rate case, you'll have many interveners, and they come from different aspects of the public. There are, environmental groups. There are consumer interest groups like AARP. There are sometimes other utility companies. There are municipalities, other rate-paying, public rate-paying entities, the military, universities, all kinds of people get involved if they think their rates are, at risk in a case. So all those parties get involved. They file their briefs. They bring their own witnesses if they want to, and testimony is all pre-filed. All the expert witnesses testimony is pre-filed. So when they get on the stand, they just adopt their pre-filed testimony as their own, and the most of the time is spent cross-examining them. So once all this testimony and cross-examination testimony is done, then that ends the hearing, and the parties are sometimes frequently asked to write briefs at the end as well. Oh, I forgot to mention, in the beginning, they can also file motions like in a regular trial where you can, try to win the case on a legal basis or something like that. But, usually they're more of a procedural nature. So usually, always, you're going to have testimony, lengthy testimony. These cases take weeks, 2 or 3 weeks to conduct. And then, as I say, the hearing examiners write up their decision and present it to the commission. And the commission decides, but usually, certainly not with a rate case, before the general counsel's office attorneys review the whole case again and review the recommended decision and advise the commission whether or not they should adopt it, reject it, or modify it. And then taking that advice into account, the commission has to make their decision on what to do. And there are 5 commissioners. They're elected from districts across the state. My district is District 1. It's the Albuquerque metro area. It's the only district that is purely urban in nature. All the rest of the districts sort of, well, they used to fan out from the center of the state, but no, let's see, it would have been 10 years ago. The district to the east of Albuquerque got reshaped, so it's now kind of a rectangle along the eastern border of the state. I mean, and it's large in geographic area. It's probably 2/5 of the state, but we are all about the same population. And what I was going to say about the rest of the districts is they have large areas of rural area as well as some urban pockets. So in any case, there are 5 commissioners. We're spread out across the state, and so we make our decisions. If there's a party aggrieved by our decision, they can appeal our decision, and appeals from our court, from our agency, go directly to the state Supreme Court. So we're sort of analogous to an appellate level court in that sense, because our appeals go to the Supreme Court. And we review basically a decision that's written by a hearing examiner who is sitting and filling the role of a trial judge, but just with a very limited jurisdiction. So anyhow, that's what our agency is. That's how we function. And so we operate under a couple of different statutes, the Public Utility Act and the Renewable Energy Act, and various other smaller acts that are more specific, like the Energy Efficiency Act and Integrated Resource Plan Act. They're smaller acts, but the 2 large ones are the Public Utility Act and the Renewable Energy Act. The Renewable Energy Act was passed in 2007, and in that act, it established what's called a renewable portfolio standard, which sets a standard for these electric monopoly companies to comply with, whereby they have to provide a certain amount of renewable energy in the mix of energy that they sell us in our homes. And that amount has to increase over time. So in 2007, I'm not sure what the amount was, maybe 5% or something, but by 2020, these utilities had to be providing us 20% renewable energy in the electricity that they sell us. So last year, in 2019, the Energy Transition Act, well, actually, wait a minute. Yeah, that was in the 2019 legislature. That was in the spring of 2019 that the Energy Transition Act was passed. And there were several provisions in that act. One was to increase our renewable portfolio standard to 80% renewable energy has to be provided to the consumers of New Mexico by 2040. And then by 2045, we have to go to 100% clean energy, which is not quite the same as renewable energy. It may contain some other sources, clean, most likely nuclear in this area. We don't have hydro energy in this area. So that's one part of the Energy Transition Act. Another very important part of the Energy Transition Act are the provisions that pertain to the closure of the San Juan generating station. Has everybody here heard about that case? Has anybody not heard about the case of the closure of the San Juan generating station? I guess everybody's muted, so you can't really say, but.
Can you give us a
thumbs up, thumbs down.
Cynthia, can you give us the short version of
thumbnail
what
version
that
of
case
it?
is?
Sure, I'm happy to.
Okay, thanks.
Well, there are two coal plants in New Mexico. They're very large and have provided the bulk of energy for the population of the state for 35 years or something. One is the San Juan generating station, and the other is the Four Corners generating station. They're both owned by PNM and a number of other utilities in the Southwest, such as, let's see, I think APS, Arizona Public Service, and Tucson Electric, and the city of Farmington has a small ownership, and there are a couple of more. I think there are three or four other owners. So they jointly own these plants, and El Paso Electric is one. Because of a confluence of events, I guess, or trends, I should say, or outside influences, as most of you know, the coal industry has started to decline. I don't know when the beginning point of its decline was, but certainly by 2010, it was beginning to be obvious. And by 2015, it was really getting to be obvious. And ultimately, the owners of these plants, I think, were looking to either get out of ownership or close them. And in 2018, the joint owners of the San Juan station filed I think it was 2018, it could have been 2017, I'm not quite sure when they filed. They filed a stipulated agreement. I think that also resolved a rate case at that time. Sometimes we let people stipulate if there were just too many issues, not enough time before the statutory deadline to complete the case. So sometimes people would reach stipulated agreement. So there was a stipulated agreement whereby the joint owners of the San Juan generating station agreed to come in to the commission in 2018 and notify the commission whether or not they wanted to continue to operate that plant beyond 2018. And all the parties had to agree, and they had to file it in time to permit the commission to hold a hearing on whether or not to approve it. We would approve it generally if a plant is going to be closed or abandoned is the term. It's called an abandonment statute we operate under, but it's walking away from it basically. It's still standing and can be operated for other purposes, but the owners wanted to get out of it. So they, in 2018, again, took some steps to indicate, like, for example, with the Securities Exchange Commission, there was a filing that indicated they were going to be leaving it, but they didn't really provide us with that information until the beginning of 2019, and even then it was a bit unclear, but clearly they were intending to close the plant, and the other parties had already indicated to PNM in 2018 that they wanted to get out, all except for the city of Farmington. What happened thereafter was there was legal dispute, and I'm not going to go into in detail, but you would have seen discussion of it in the newspapers and in the press, having to do with our agency insisting on being able to have jurisdiction over determining whether or not the closure costs associated with that plant should be borne only by the ratepayers or only by the utility, or some sharing of those closure costs, because the plant was going to be closed early. Now, this was unusual, but the coal industry was definitely on a downward slope in terms of its viability, and so the companies wanted to get out sooner rather than the regular time. What that did, though, was that left what's called stranded costs. I mean, costs for basically paying for the capital investment of the plant that the utility was earning over time from revenues from ratepayers. But if they get out of the plant early, then they no longer theoretically should be collecting those revenues. And their conundrum was, how do we cover these lost revenues? Do we take it out of our shareholders' dividends, or do we have the ratepayers continue to pay for it? They have enjoyed the benefits of the plant for a long time, and it should be a policy decision. It is a policy decision And it ordinarily rested, up until then at least with respect to these plants, rested with the commission. However, without going into the details of the merits of either side of the issue, to make a very long story short, what happened was the legislature in 2019, well, in 2018, they tried to pass a bill, it didn't pass. So in 2019, it was wrapped up into the Energy Transition Act, and it made that policy decision for the commission. And it said that, and this is a part of the language in the, well, I don't know the exact language, but it's part of the Energy Transition Act. It provided that the utilities would be allowed to collect 100% of the closure costs from ratepayers. And so we will be paying for those closure costs going forward. But two other parts of the Energy Transition Act are really important. One I already described, which is the increase in the renewable portfolio standard, which will greatly speed up the rate at which the electric utility companies have to perform in terms of providing more renewable energy in their mix of energy that they service. But the third provision is a securitization financing mechanism, which also, to make a long story rather short, provides that it provides that the financing for closure costs and financing for closure costs basically will be done through issuance of a bond rather than simply charging ratepayers through the traditional rate-making mechanism. And those two different methodologies have two different rates of interest. The traditional rate-making mechanism involves analyzing in a rate case what the capital cost the company has incurred and determining what their revenue requirement is, and then providing them a return on their capital investment. So that return is generally around 9 or 10%, sometimes 11. So you hear about that steady 10% you can get on your dividends if you invest in utility companies. That's that 10% that's being paid by ratepayers. And that's the profit the company gets to make on their capital investments, assuming they've been made prudently. So that's one way the company, those closure costs could have been financed. Another way, by allowing the company to continue to earn rates with the profit attached going out into time, over time. The other way to finance it is to permit the utility to issue a bond and securitize it, which means you put a line item on the bill and announce to the world, especially to Wall Street, that the ratepayers are backing, essentially paying back this bond. Ordinarily, the utility backs it through their assets, but with securitization, you shift the risk of paying back that bond to the ratepayers. And that sounds kind of bad for the ratepayers, except it's, the likelihood of the company going bankrupt is not high. So, and the benefit from doing that from Wall Street perspective is that becomes a AAA rated bond, which enjoys the lowest, for ratepayers interest, it enjoys the lowest rate of interest, like 3.5% interest. So ratepayers end up paying back that money that is owed on the bond at a 3.5% rate of interest, as opposed to the 10% rate of interest that they would be paying for those closure costs over time through the traditional method. So the difference between that 3.5% and the 10% represents hundreds of millions of dollars of savings for the ratepayers, from what would otherwise be an enormous amount to pay, but to be something much less. Plus, with the provision in the Energy Transition Act of accelerating the delivery of renewable resources, renewable sourced energy to ratepayers, their bill effect will be changed, because if you look on your electric bill, and I have one sitting around here somewhere, I should just show you that on the back, I don't know if you study the back of your electric bill, there is a line for fuel costs. And for fossil fuels, it's a certain amount. If you have renewable fuels, that amount is zero. So the bill impact of renewables is positive for ratepayers. So those were the financing, those were the benefits of the financing mechanism in that bill. So the Energy Transition Act, just to summarize again, it did three things. It provided a speedy exit from the coal plant in San Juan, and the San Juan generating station. It provided a securitization mechanism that allowed the company to raise money quickly through a bond issue and minimize the impact to ratepayers for paying it off. And it provided a new renewable portfolio standard that greatly accelerated renewable energy. It also provided $40 million in what I want to call, I call rescue money for the affected community. The mine workers were provided $20 million in severance pay and retraining costs. And then there was another $20 million that was provided, that will be provided to the community for economic development projects to help them rebound from the loss of, the hit to their economy from the loss of the employees and the vitality that was provided by having that plant operate there. So it was really quite a comprehensive bill to address the social, environmental, and economic impacts of the closure of that plant. And I didn't really appreciate how comprehensive it was until we started to apply it. In the cases that followed before us, we had two cases. One was the case just determining whether or not the plant should be abandoned, and the statute pretty much directed us to declare that it did, but there was evidence adduced and so forth. And so we did that. And there was some fighting because the community of Farmington really wants to keep the plant open for jobs, and they have an objective to purchase the plant. Well, under the stipulated agreement, they had a right to purchase the other owner's interest for $1. And I don't know if they've actually gone through with it, but they have the right to do that. And they are negotiating with a company called Enchant Energy from Canada, which is interested in retrofitting that plant with carbon capture and storage technology to capture the carbon stream, the waste stream coming off, purify the carbon dioxide, and then ideally under their plan, they would have pumped it down to the Permian Basin and used it as a drilling fluid before storing it in appropriate underground salt dome formations. It's up for grabs what's going to happen with the Permian Basin drilling. Certainly there's a big effort by the oil and gas industry to keep it viable, so that may still come to pass. But in any case, whatever happens with that plant is not going to be paid for by ratepayers at this point, but it may not cease to operate, or it'll cease to operate for a while, but it may be that it'll be brought back in order to provide coal-sourced energy with the application of carbon capture and storage technology. But that's, whether or not that'll succeed or whether or not they'll even get financing is unknown at this point, but it was something that was part of that case. So the two cases, there was the closure case, which we dealt with, and then there was a case having to do with the choice of replacement resources. And we just finished that case, well, maybe 6 weeks ago now. And the time for appeals has passed, and when there haven't been any directly, so that case is finished. And that was a very interesting case because the company made, PNM made its application and presented choices for replacement resource energy, replacement resources, that is, and their choices involved, you know, all solar or all storage or all gas, none of which was realistic, and they said so. The company said, we're just putting these out here, but we know none of them would be operational. And then they had one other that was actually what they probably really intended to be their choice. That was a mixture of gas and a certain amount of solar, not a large amount of solar. And frankly, I don't recall whether it had some storage. It probably would have had to have had some storage. I think it did, to accompany the solar. But frankly, I don't remember at this point. However, the way that case progressed was also part of that stipulated agreement, which I think was the one I was telling you about at the beginning, the stipulated agreement that required the owners of the plant to come into the utility, into the commission by 2018 and let everybody know whether or not they were going to continue to run that plant. Also contained in the provisions of that stipulation were some provisions that pertain to how this hearing would proceed. And one of the provisions involved permitting interveners in the case to provide their proposed options for portfolios of mixtures of resources to use as the replacement resources. So there were several interveners that actually did that. And that was quite an undertaking because they had to, you know, get experts to go over all the information that PNM had to propose portfolio of resources. To make this long story short, the portfolio that, and they were also permitted to use, the interveners were also permitted to use the optimizing software that PNM used. So all these different choices of portfolios were all able to be viewed on equal footing by the commission because everybody got to use the same optimizing software, which has never been done. Well, it sort of has been done in the past in previous cases, but in those cases, the interveners had to pay quite a bit of money to be able to use the optimizing software. This time they didn't. So because of that, there was a choice that ended up being a portfolio that ended up being chosen that was not what PNM wanted, but it was something that was possible because of the terms of the Energy Transition Act, which did provide guardrails on values you had to apply in making choices of what would be the winning portfolio. And it turned out it was a project that was all solar plus storage, except for maybe 24 megawatts of distributed energy resources, which is anybody familiar with that term, distributed energy resources? If you've got solar panels on your house, that's distributed energy. That's a distributed energy resource. Anything that's behind your meter generally is, like, for example, if you have a smart thermostat that stops your air conditioning for a couple of minutes every hour, for example, that's a distributed energy resource. If you look at, you know, a community full of those smart thermostats, and in the aggregate, they can have an impact of reducing the use of that energy, and that reduction can be considered a resource in a way. So there are numerous technological applications now behind the meter that are not in the control of the utility, obviously, because they're behind the meter. They're between the meter and the home or the business that can be controlled by the property owner. And in the aggregate, they're considered resources. And it's really interesting. In large parts of our country, we have, but not yet full blown here in the West, there are wholesale electricity markets where electricity is bought and sold among utility companies and other generators of electricity, and they actually trade and buy and sell distributed energy resources based electricity as well. So it's definitely a thing, and it's monetized. But in any case, the winning option portfolio for replacement resources for the San Juan plant involved all solar and storage, and with some small amount of distributed energy resources. The other thing that was kind of outstanding about that, and what I wanted to mention to you was the dictates of the Energy Transition Act in arriving at what the legislature felt would be a just resolution of the problem of the impact on the community. The community was particularly concerned that because the coal plant provided an enormous tax base for the school district there, that as much replacement resources as possible be located within the school district. And this project was had quite a lot of megawatts located within the school district. And then otherwise it had the remaining megawatts located in the affected community area, which was also something provided for in the statute. With the economic effect of bringing approximately $900 million, almost $1 billion of investment into the area in order to build all the facilities that were necessary to provide the electricity that was needed to replace what was being lost by the closure of that plant. So, I'm sorry, I know this is kind of wonky and technical and remote from probably what you're used to thinking about. But the thing that to me is outstanding about this is that this is the first time we've closed a coal plant in our state. And amazingly, it's been replaced by all renewable energy, or a resource, a distributed energy resource that doesn't pollute the air. And it did so because the statute required it. And the other statutes we have don't dictate the same values that the Energy Transition Act stated. I mean, they wanted to have economic justice for the community by requiring building in the tax base, but they also had provisions whereby the choices had to, the commission had to consider choices that provided the least disturbance and required the least reclamation of land where the mining operations had been, and also that had the highest ratio of capital cost to fuel costs, which, if you think about it, given that renewable energy has no fuel costs, that is a provision that strongly favored renewable energy. So explicit in that statute were provisions that put a thumb on the scale heavily for renewables and energy sources that didn't pollute the environment. Our traditional statutes that we have to comply with, the Public Utility Act standard for choosing resources is that they need to be the least cost choice of all feasible options. So we don't have at the commission the legal tool that we had in the Energy Transition Act to apply to replacement resources to other kinds of fossil fuel plants. The Energy Transition Act applies to the closure of only these 2 coal plants. They don't apply to the closure of, say, gas plants, of which there are many in the state. So the gas plants won't be held to quite the same environmental quality standard that the coal plants were held to in this case. So going forward, however, they will still be subject to the standard that we have to apply, which is, the best economic choice given all the feasible options. The other thing that was good about the Energy Transition Act application to the closure of this plant was that PNM had to issue requests for proposal. They had to issue an all-source request for proposal for bidders to bid on how to replace the resources. And they got over 300, I think over 350 bids with some of the cheapest solar plus storage projects in the nation. I mean, it made nationwide news in the utility industry news in any case. And so it was eye-opening insofar as the market is really there that establishes that you can procure, utility companies can procure clean energy sources at prices comparable and better than fossil fuel resources. And that there was not only competition in prices, but that there were many, many parties interested in providing those resources. And not all the prices were optimal, but, and we weren't able to see all those prices, but nevertheless, it's really a paradigm shift in our state for moving forward rather boldly now that we know what we know from this case to working to provide choices as we go forward in implementing the Renewable Portfolio Standard. Now the three companies, El Paso Electric, Southwest Power Service, and PNM have to come in and provide their applications for approval of their renewable energy plans that they have to submit to us on a regular basis in order to comply with the Renewable Portfolio Standard requirement going forward. Here's the question, what is the time frame for these replacement energy sources? By 2030, they have to be at 50% renewable energy in their electricity that they provide into our homes. That's their retail sales. We're the retail customers. Everybody who lives somewhere and pays an electric bill, they're buying retail electricity from these utilities, which has to be 50% by 2030. Now, I was watching my electric bills over the past 6 months from the beginning of the year till now, and honestly, if you want to look on the back of your bill sometime, you'll see a charge for renewable energy and then a charge for non-renewable energy. And the renewable energy was not at 20%. It was like at 17% 1 month, 19%, 15%, it varied. I think now it is at 20%. So it's not always exactly right. And, but I believe it's at 20% now, and it's been at 20, 21%. So I think the utility got there. But going forward, there will be a period of time. We saw data, I don't know, a month ago presented by our staff that compiled some information from the three utility companies that showed that, let's see, I guess with the exception of PNM, which had just gotten to 20%, the other two were not at the right percentage and nobody thought they were going to get to the 25% when they were needed to be. Until they weren't going to get to where they were supposed to be until 2025. So it's kind of a question in my mind, how well compliance will be going forward, how well that will be implemented by the companies, because they're challenged. This is a challenge. Many of the companies, there's three, they all have gas plants that are still in operation, and several of them want to build more gas plants, and those generally have a life of like 40 years or something, and 45 years. If they want to, they will need to have to close them according to the schedule. And the schedule is, okay, by 2030, 50% renewables. By 2040, 80% renewables. That's only 20% non-renewables. And by 2045, that's 25 years from now, it has to be 100% clean energy. So, unless carbon capture and storage comes to the fore and is somehow a miracle technology that will permit the continued operation of gas plants will have to be closed. So that raises the question, does it make sense to even build more? And that's a question that comes up and that will be coming up in cases. It came up in the PNM case, and PNM in this plant closure case with respect to PNM wanting to build more gas plants. And testimony was given by PNM witnesses that they intended to run those plants for 18 years and then abandon them. And then the question is, well, who pays for those stranded costs? Or are you going to sell it to someone on the wholesale market, and it'll be run as a merchant plant and it will continue to operate, which is not, runs counter to the purpose of the energy transition law. So, those are issues we're going to have going forward. I had titled this part of the talk, the PRC and the ETA, what took so long? And really, maybe it should have been titled the legislature and the ETA, what took so long, because really we couldn't have done this without the appropriate laws in place. And we got that with the ETA, at least with respect to these coal plants. And with respect to the beefed up on steroids renewable portfolio standard that we have now. The renewable portfolio standard, I think, will help us enforce requirements that will lead to clean energy. Clearly, that's the objective of the law. So I feel really privileged to be on the commission at this time because, I'm able to be a part of this renaissance, really. It's a real change. As I say, it's a paradigm shift. We're shifting from fossil fuels to renewable fuels under this statute. So I don't know where I am on time right now. Let me take a look. Well, okay, so I've talked close to an hour. We could take questions now, or I could just talk about the appointment versus elected issue briefly, because I did cover some of the background in it. If you want to
take a couple questions now?
Let's do that, yeah. Anybody got any questions?
Looks like Randy has one.
Oh, there's a chat. There's a bunch in the chat. I'm sorry, I didn't look at that. I don't know if that's all questions. Okay, our staff attorney specifically charged with representing consumers or ratepayers? Boy, that's the question. It's the public interest. And the public interest is defined in case law, is the balancing of interest between the consumers and the shareholders of the utilities, the companies themselves. So when I was a staff attorney, I didn't like that. I thought I should be representing the consumer interest. Actually, the Attorney General's office is an intervener, a standard intervener. I forgot to mention that. They're not always in all the cases, but they're in many of the cases. And they represent the consumer interest. However, it's not really a level playing field. I mean, in the aggregate, the environmentalists, the consumer, AARP, Attorney General's office, and other interveners, they all sort of add up to the other interveners being mostly consumers, large power consumers and so forth. Those in aggregate sort of amount to the kind of legal firepower that a utility has, or at least PNM has. I remember in a recent rate case, not all that recent, P&M had 25 witnesses, and all the other parties combined had 24 witnesses or something, or 26. So I'm glad you asked that question, because staff technically is not supposed to be representing consumers and ratepayers, which are, in my mind, the same. They have to presumably balance the interests of the utilities and the consumers in the arguments they make to the commission. The problem with that, in my mind, is it should be the commission itself that balances the interests, because we're the ultimate decision maker. So I really don't know why it started that way, and I think it's something that somebody should look at the legislature and revise, because I don't think it makes sense for the staff attorneys to do that, but that's what they do.
Okay,
So the next
thank you.
question is, what's that?
Thank you.
Oh, okay. Oh, that was your question? Okay. So here's another question. What is the time frame for the replacement? Okay, so I answered that. Oh, your August 25th bill is 13.7%. Okay. You know, I think I'm gonna have to start an inquiry into why this is happening, because it should be 20%. You're looking at the renewable energy part of the bill, right?
Yes.
Okay. My bill should be the same. We'll look at that. All right, okay. So the next one is, I do want to hear about the pros and cons of elected versus appointed. Okay, fine. Well, if we don't have any more questions on this case, I can go to that, or this part of the talk.
Sounds
Nobody
good.
else? Okay. Okay, so as I mentioned before, when I first worked at the commission, oh shoot, well, that's all right, it's over. When I first worked at the commission, the commissioners were appointed and by the governor. And I don't know whether there was a vetting process, to be honest with you. I don't think there was. But in any case, oh, thank you. Somebody else said there's this 13.7%. I'll have to do something about that. So they were appointed by the governor, and it was a very professional batch of people. I thought there was one person who was a woman lawyer, who was a utility lawyer. There was a gentleman from New Mexico State who was a utility commissioner, a utility economist. And then the third person was a businessman. And I'm not sure, I didn't really know what business he was involved in, but maybe it had been utilities, I'm not sure. But he was very astute from a business perspective. And so, their decision-making was pretty sound. When I returned, as I say, most of the commissioners, actually with the exception of the one from Albuquerque, Jason Marks, he was a very excellent commissioner. Jason knew what was going on. He was just out of law school, but prior to law school, he had been a partner in an accounting firm, so he was very good at cost accounting. And so he was great to have on the commission. And nothing got past Jason. But the rest of the commissioners really weren't, at the same level of performance. And in the interim, the structure had changed. And then in the 90s, the legislature passed a resolution that put on the ballot a proposed amendment to the Constitution, changing the commissioners from being appointed to being elected. And the resolution also combined the Public Utility Commission, is what they called it at that time. It was just a name change from the Public Service Commission. Combined that agency, which was just regulated utility companies, gas, electric, and water, with the State Corporation Commission, which regulated a number of things. And it was a place where you registered corporations, but it also regulated the insurance industry. It housed the fire marshal. I think it also had transportation, common carriers, and telecommunications. They combined those two agencies. The State Corporation Commission had 3 elected commissioners. So, and they had a history of corruption, and the Utility Commission did not have a history of corruption. And they combined the two commissions And rather than keeping an appointed model, the legislature chose the elected model. And they also, I don't know if these were, the requirements for getting elected were low. All you had to do was be a state resident, 18 years of age, and not a felon. And you could run for election. And I don't know if those standards applied for the Corporation Commission in the past. I heard they were standards from someplace. I don't know whether it was the legislature or the Corporation Commission. But in any case, nothing like that, had anything to do with the Public Utility Commission at that point, because they were appointed. So, and I paid $90,000 a year, which was a lot of money for a state employee at that time. So that job then became a target for ambitious politicians who didn't need to know anything about regulating utility companies, but did know how to get elected. And so in 1999, I guess, let's see, I don't remember the year when that was on the ballot, but the voters approved electing them, obviously, instead of appointing them. And the argument was, this is good government, it's more efficient, you put all these things under one roof and it'll be better. The staff, there are some commonalities, because in the insurance industry, you have to pay rates. Actually, there's no commonality because the insurance industry is not a monopoly industry at all. So the analysis to determine whether those rates are fair or not is different. But in any case, it was combined, voters approved it. People started getting elected. And between 1999 and now, it's been a span of 21 years. We've had 2 commissioners get convicted of felonies while on the bench at different times, and other commissioners, doing other things that are less than a felony, but not good things. One commissioner had a lawsuit, a sexual harassment lawsuit filed against him, and the state had to settle that for $800,000. There was a commissioner who, since he was coming from far away to get to Santa Fe, would spend the night frequently at the home of a regulated utility company executive or something. I don't know who exactly it was, but that was an ethical violation. There was a commissioner who was caught in the airport in Las Cruces, in El Paso, with her hash pipe in her purse. I don't know if you remember that. They're just, behaviors that you didn't see before. And more importantly, the decision, I don't know if it's more importantly or not, but equally important certainly is that there was a much higher frequency of overturning commission decisions in the Supreme Court. So it's not been good. And in 2017, the legislature did pass a law that did require some minimum professional qualifications and education qualifications. You have to have at least a bachelor's degree in certain areas, or a professional degree in law, economics, or engineering, and something else, or an MBA. But with the bachelor's degree, you also have to have 10 years of experience in a field regulated by the commission or in the energy sector. And with the advanced degrees, you still have to have a combination of the advanced degree and some other work experience of the same description, totaling 10 years. So, however, if you don't meet those standards, nobody will punish you. All you have to do is file an affidavit with the Secretary of State that you meet the standards. And then it's up to your opponent, if you're running in a race and you have an opponent and they're looking at your qualifications, to challenge your qualifications once you file for candidacy. And you have to do it within 10 days of the filing. The opponent has to file a suit in district court to challenge your qualifications. That's happened once or twice, not often, because, I don't know why. It varies. I've heard that district courts don't like to be put in a position of, preventing someone from running when voters deserve to have choices and that sort of thing. So I don't know, but in any case, there's no teeth to that. And so it's sort of it's a set of standards with no real meaning because there's no way to enforce it. So there's been a movement for, almost 5 years now largely from, I don't know, I shouldn't say largely, but certainly there have been commissioners independently going to the legislature, asking somebody to carry a bill to return to appointing commissioners, but also now from other sources as well. So this, such a, well, it's not a bill, it's a resolution. Such a resolution passed the legislature this past year, and there will be a, there will be a measure on the ballot, and a proposed amendment to the Constitution on the ballot in November to return to appointing commissioners. And I would strongly encourage you to vote for it because, in my experience, we do much better with appointed commissioners. And also, there is an enabling statute that was passed, a bill that was passed in the last legislature, which will come into effect if that amendment passes, that provides for a vetting process to be implemented. So the governor just can't pick 3 people she likes or whatever. They have to be, it has to be a list provided to her from a committee that has vetted the applications. The committee is chosen, it's a 7-member committee, and the members are chosen by the following people. One choice each. The Speaker of the House and the Minority Leader of the House each can pick 1 person each. The President Pro Tem of the Senate and the Minority Leader there in that House can each pick a member of this committee. The Secretary of Energy and Minerals and Natural Resources can pick a member. The Secretary of Economic Development can pick a member. And the governor can pick 1 member, but it has to be a tribal member. So there are 7 people on this committee, and they can send a list of people they approve of to the governor, who can pick. And then, you know, I don't remember this part, but I heard last night somewhere, or in a conversation last night, that it has to be, these picks have to be, they have to have the approval of the Senate. I'm not sure about that part, but certainly they're vetted. The terms, our terms are 4 years now, and we can run for 2 consecutive terms. Then if we want to run for other terms, we have to sit out a term, and then we can come back and run for 2 more consecutive terms. We can do that, continue, you know, going forward. There's no limit on that. But under the new provisions, there would be 6-year terms, and my 4-year term, which would commence in 2020, would have to stop in 2022. And the reason is, right now we're staggered. We have two candidates, myself and District 3, run during presidential years. And then the other 3 run in the midterm years. So we're staggered. You know, we have 2 new commissioners coming on theoretically 1 year, and then 3 new commissioners coming on the next cycle in 2 years, 2 years after that. So it's to minimize the newness. You know, you don't want all of them being elected all at the same time. Same way with these 6-year terms, they need to be staggered. And so the governor, well, I don't know, the way the law is written, the governor will pick in 2022, she will pick the first batch of 3 commissioners. 1 would have a 2-year term, 1 would have a 4-year term, and 1 would have a 6-year term. And so for some reason they chose 2022. Well, probably the soonest year they could begin this once the measure passes in 2020. So 2022, if this measure passes, I will actually have a 2-year term instead of a 4-year term that I'm running for, because the effects of this law will come into play and my term will be shortened pursuant to that. And the governor will then be in a position to pick 3 commissioners going forward. So that's all I know about that. And are there any questions on this topic? Here's someone who says, did I hear you have an opponent this election? Yes, I do have an opponent. I do. The good thing about this district is that for me, is that there are more Democrats than Republicans. And however, there's a pretty fair number of declined estates. So, but I don't think I think the gap is large enough between me and my opponent, not between me and my opponent, but I mean, in terms of the registered Dems and Republicans, that even my opponent would have to win all the declined estates, and then I think some Democrats before she could win. However, that analysis is loosely based on the number of people who were registered in the last election. But that number can vary from election to election. And in fact, that might be the average of the last 2 elections. So that number can vary. If you don't look at the most recent election, then it's different. So there's some uncertainty there. And I'm certainly taking my opponent not for granted. I'm taking it very seriously. It would not do, just because of the numbers just to get the demographic numbers, for me not to run a vigorous campaign. This is the first time in 4 election cycles there's been a Republican in the race. I'm a Democrat, in case nobody knew. So, so it's a novelty for me to run against an opposing party opponent. But nevertheless, it's there, and I'm running very vigorously. I'm raising money. I'm printing cards. We're not door knocking, but we're dropping literature on doors. We're doing, I don't know, a new thing now, digital advertising, and various things. I'm working hard, and I have volunteers helping me. And yes, it'll be, it's a hard-fought kind of campaign, like everything. I did see one other question now, and it said, will the geographic areas be the same? No, they won't. There will be 3, not 5, and they won't be those 5 areas at all. It'll be, the only provision about geographic diversity that I recall is that the commissioners each have to be from different counties. So that provides some geographic diversity. It won't be as much geographic diversity as we have now, because we're really quite spread out now. However, with the gerrymandering that we actually have what I think is more of a disproportionate rural impact on decision making on the commission because of the shape of the districts. But on the other hand, I'm not quite sure how you could avoid that, because districts have to be equivalent in population or close to it. And well, you could avoid it. You could split Albuquerque out too. I don't know. You have to, I guess we'd have to resort to questioning the legislature, how districts get divided, but they're not creating districts per se. They're just saying that commissioners have to be from different counties. So Dave, I think I covered everything. I hope it wasn't too boring. I mean, people were, I can't see people's faces. I can't tell, but to me, it's something
It's pretty good. I got knocked out just now. It took me, I lost about 5 minutes.
Oh, shoot.
Where I was knocked out of the meeting.
I can feel you in.
But I hope it shows up on the recording. So yeah, I was getting my questions answered. I appreciated what you had to say about this. It's a constitutional amendment on the November ballot.
Correct.
So yeah, that looks like something to take interest in and tell your neighbors about.
Please do tell your neighbors. Please, everybody, please tell everybody to vote for that. Oh, you're welcome. Tish Morris is saying, oh, to everybody. Thank you. Yeah, please vote for that amendment. I think we'll have better performance on the commission with more efficiency. And I think it'll redound to the benefit of the agency. I think we'll be able to retain better staff and that sort of thing. So I think it'll be a good thing. So I want to thank everybody for listening.
All righty. Well, thanks, Cynthia.
I love this stuff.
Very interesting.
Yeah.
Okay.
Thank you, Cynthia.
You're
All
welcome,
right.
Randy.
So we still don't know what we're going to do in October. But Jerry Aldrich, you're there. What do you think about having a panel to discuss nuclear power? What can be done to sort of just change, promote the dialogue on that a little bit, and um, sort of, maybe review where we are. Would you be interested in that, Jerry?
Well, I'm interested, but I'm not sure what I could contribute except questions. Um,
Okay. Well,
I happen to think that the integrated fast reactor technology needs to be looked at more because can serve two purposes, and the costs can therefore be spread uh, out. First of all, you can generate power. Just in that sense, it's a standard thermal plant, sort of modular. They come in two sizes and can be, at least the reactor part, can be built in a factory and then brought to the site and put into a prepared site. So you can expand by adding more modules like that. But the integrated part is the main thing, and that is on site. There is a recycling of the fuel. You don't take the fuel off and put it in a hole someplace. You recycle it, separate out the actinides, and then you have concentrated um, decay products primarily, but also some induced radioactivity, which still will have to be disposed of, but the volume is much less. And it will burn uranium-238. So we don't even have to do more mining. We've got lots of uranium-238. You go into a battlefield in the Near East and mine depleted uranium
There you go.
munitions.
Well, I'll talk to John Covan, and maybe we'll see if we can pull together a panel for.
But I don't know who would get for an expert on that. That I've told you all I know about it right now.
Covan about, but he might have some Sandia buddies in mind. We'll see what we can do.
Well, I'd be interested in it for sure.
Okay. Well, thanks, Cynthia. That was fascinating stuff. Some encouraging parts there. So,
thank you. I was just sitting, I guess, here thinking, I don't know if I've signed up, if I can be a member. I want to hear this one next week. Or when is it? Next month or something? How often do you do that? That sounds interesting.
It would be October 2nd Wednesday.
Second Wednesday.
And I encourage you to watch the video from last month, August. Had a very interesting talk from.
What was that about?
Yeah. So, but if you go to nmsr.org,
okay,
there will be about page that'll point you to the how to join if you like.
Okay.
Yeah, we'd love to have you.
Great.
Okay.
Dave, a question for you.
Sure.
You have filled in the TBD then on next month. The Keith Matson is going to be on the.
Well, I think Keith really wants to wait until we have in-person meetings. So
okay, so
I'm not ready. I'm not sure if we're ready to rush into that.
But so we may or may not have one next month. Is that
that's
correct?
Right? He is still TBD
okay.
to when this pandemic.
It was a point of clarification, not a.
Yeah. So we're still on pandemic status here. Okay. Well, thanks everybody.
I had one other
sure.
question. Have you looked into the possibility of, I can't remember the guy's name. He's in earth sciences at UNM and a specialist in Southwest drought. And,
okay. So,
and in particular, the monsoon.
David Gutzler, I think, was who you were.
Yeah, I guess.
Gutzler. Yeah. I could try to line him up there. It's been a while since he's talked to us.
Right, and one thing we would like him to discuss, although he may not have been directly a contributor, is to the determination that we have been in the Southwest, meaning from the 105th meridian westward and essentially from North Mexico up to through the Utah and Colorado tier has been in an average drought for the past 10 years. 20 years, the 21st century. And it looks like it's continuing.
Yeah.
But the thing about average is, the drought monitor and so on, that's purely episodic. You could be in a drought one week and out of a drought the next week. But when you average all those two, we're in a drought that rivals those of pre-contact times.
Yeah. Pre-Columbia. All right.
Pre-Columbian times. I guess we can still say that.
Oh, yeah. All right.
The ones that moved the Sazi out of Chaco Canyon and so on.
Yeah. Okay. All righty. Well, I'll look into all that. Thanks, everybody, and take care. Stay safe out there.
Thanks very much.
All
Yeah,
right.
thanks
Pleasure
again,
meeting you
Cynthia.
guys. Thank you.
Take care. I'm going to pull the plug here. Take care,
Bye.
everybody.
Bye.